do is change. I mean, this is literally changing a setting in the electronic software to say, send it here versus send it here. It would have been the easiest thing in the world to do. And I guess none of us would be sitting here discussing this. So it's just maybe a selective application of the law over 7 years here to say, well, somebody has been doing something that's been perfectly fine, and all of a sudden we're going to choose to determine that we don't like what they're doing. And just to understand, this is not, you all deal with this all the time. So you have a lot of depth of knowledge. Even as a state rep, we have to deal with a lot of different issues, but sometimes we don't get very deep on them. Sometimes I'm very deep on issues, for example, energy or something like that. But when it comes to school or healthcare, those are issues I'm not as adept in. So it's just, that's the only statement I guess I'd want to make, is this is something that's been going on, and then all of a sudden it's a problem through all these audits and everything else.
Well, from my perspective, it's difficult for me because you've been a politician for many, many years. And it seems the basic principle understanding should be that money that goes into the campaign account is for the campaign, and money that is your personal money goes into a personal account. And I don't know when and if that setting was available, but, and I'm not, it seems to me that you found a way to put money in and take it out where there's no accountability. And you've said 60 to 70 times you've been able to do that. And you're asking us just to completely rely on it. Now, we just made a decision today on the Elkins case where this gentleman used it 651 times for his own personal candy store. And I don't know if that's accurate or not with you, but you've just told me 60 to 70 times you had money go into your campaign account. You've swept it out, and nobody knows really where that went or what happened with it. And there was no reporting to the state about it.
Well, again, because I was told if detailed records are kept and you're not using it for the campaign, and it is not related to the campaign, then you don't have to file those.
Then why would you put it in the campaign account if it was not for the campaign?
It was really just a matter of convenience because it takes considerable time to set up a Pyrex account and all the backup with that. I've now since, of course, done that, considering there's been some confusion with what is allowed and what's not allowed. But that's really the only reason. It was just a matter of, well, they told me it was okay, and path of least resistance. If it's okay and I keep detailed records, we can continue on with that path. But of course, we don't do it anymore. But here we are.
I have a question. I would like to know, you said that you've said that numerous times, and I believe that you were told that, but may I ask who told you that you did not have to report it if you kept detailed records?
So I would point to 3 places primarily: the Ethics Commission, in-house, the Ohio House Attorneys, and then also the audits I've had with the Secretary of State over the years.
Thank you.
Did you specifically tell them you had money going to your account from this pirate for CCW and you were just sweeping it out of the account?
I did, and I was specifically told, as long as you're keeping detailed records and it's not being used at all for any campaigning or expenditures for anything to do with the campaign, that's allowed. That there's nothing in the law, that it may look inappropriate, but there's nothing specific in the law that says you cannot do that. Even that case was brought up.
The Secretary of State's office told you could put money into your campaign account and then sweep it out without recording it.
I specifically told them how the process worked, and they said, as long as there's nothing in the law that prohibits that, as long as you're not using any of that money for your campaign and you're keeping detailed records of it. That's what I was told.
Do you have any records, anything in writing as a result of the audit with the Secretary of State over the years?
There are lots of phone, as I've stated in my I have a lot of phone calls and emails and the actual audits themselves from the Secretary of State over the last 7 or 8 years.
So do you have a name of who would have audited it that you would have had that conversation with?
That may or may not be public record. I'm going to be honest with this commission. There was a particular person at the Secretary of State's office who was fairly unhappy, shall we say, about these violations being filed, who's worked with me for a long time. I do not wish to mention his name because I potentially think he could get fired.
All right, is
And
it safe?
I don't want to do that to him. I'd rather have you all file a violation on me than have him. And this is no one I know personally. This is
I
just
understand.
someone that was assigned to me over the years and has done a few audits here and there over the years. So I'm just, with all due respect, I don't want to get someone else in trouble. I'd rather take this on me if that's what this commission decides, than get someone else in trouble for, what they may or may not have done.
Okay. Thank you.
Mr. Richter, is this something that we could get through subpoena process through the commission to be able to get the emails and the records to see if this is validated? And I understand the burden's not on us.
Right. I mean, we certainly have an ability to issue subpoenas. Yes. I mean, that is one of the basic elements that the commission has available to it if it wants to utilize that as a means of getting additional information.
If I would add something,
Yes, please go ahead.
this is just my recollection, but both with the Secretary of State and the Ethics Commission and the Ohio House Attorneys, unfortunately, the specifics of this were verbal. They were over many phone calls. I don't recall anything actually being putting in writing other than that case being sent to me. So I'm not sure. I mean, obviously this commission is free to do whatever it wishes. I'm just letting you know that there were several conversations, and I recall them all being verbal, because I was concerned about this myself. I said, hey, I don't know this part of the law that well. I want to make sure I'm being compliant.
Do you have any memos to the file that document the conversations that you would have had with somebody from the Secretary of State's office or the ethics?
If I did, you all would have them. Trust me, I hunted.
Okay.
I have a question.
Sure.
When you say the money is swept out of the account, can you describe for me that process? I understand the electronic process of getting it in the account.
Mhm.
How long does it sit there? When does it come out? How does that happen? Is that an electronic process? What's just the procedure
Sure.
that happens there?
The process we use, and it's me specifically and no one else, is when the class date occurs, people have to pre-register for the class because they're reserved seats. So in the case of the fee would come in, the Pyrex company takes a 8%, or I don't remember what it is, out of that amount. And then on the class date, after the class is completed, then the money is swept out of that account and put into another account where checks are written to the instructors and any expenses that are had or donated away.
Okay, and when you say money is swept out, what does that mean? That means you go in and you do an electronic transfer from that account into a what account? A business
That's
account?
correct.
What kind of account does it go into?
That's correct. Into another account. Yep.
And is the other account your personal account, or is that a business that you own, or how does that work?
Actually, a lot of times it was transferred to Venmo. And then a lot of the guest instructors that I have were they were usually paid with a Venmo account, which is the way most people started paying, honestly. So we really weren't using this very much.
Okay.
So not every person who signed up for a CCW class with you would pay through Pyrex. Maybe some of them were paid through Venmo initially.
Most did not. And as you can see from, I don't remember what page it is here. Page 4. Yes. In that particular class, no one paid with the Pyrex service. So most people preferred checks or Venmo. It just depends.
Thank you.
Mhm. Anything else for Representative Vitale?
I do have a clarifying comment about an earlier question.
Go ahead.
That 60 or 70 approximate number was over a long period of time. In the period of time when this particular violation was filed, that number is probably more like 10. I don't know that makes a difference. I just want to be extremely clear about what we're talking about. So.
Okay, anything else? Hearing nothing? Mr. Richter? Any thoughts?
I mean, obviously, as I always say, I mean, I make recommendations on what to do with matters when it reaches the preliminary review stage, and that a hearing is for the commission members to review the evidence presented, make a determination on their own. I don't make a recommendation per se. And so, certainly I've asked questions, and I think we've discussed potential separation of account issues that may be there. Other than that, it would appear that Mr. Vitale has made a reasonable response to all the other elements
Okay.
contained herein. But, it's up for the commission to decide at this point.
Okay, thank you.
Mr. Chair,
Yes, Ms. Cunningham.
I understand we have Commissioner Tavares and Commissioner Beatty are not part of this meeting, right?
That's correct.
So we're down to 5,
Correct.
and we need a 4 yes to respond.
Correct. I'll interject, even though you weren't asking me, but yeah, we need 4 votes in order to take any action, whether it's violation, no violation, if a violation is found, to impose some sort of appropriate sanction. Again, whether that's good cause, fine, referral for prosecution, those are all available, but it takes 4 votes to do anything.
So I don't know. I'm wondering whether we want to close the hearing, continue for our decision, have a full panel, make sure they listen to the rest of the hearing and vote so that we have an adequate number of members, or proceed today. And I just throw that out there for the commission to consider. Because this is and also for Mr. Vitale, this is an issue that's coming repeatedly before us, and this is recently. And this is just another one of those cases with different facts, certainly. But I throw that out there for the commission.
I guess the question I would throw to Mr. Richter is, we've opened up, we came for hearing today. We've heard testimony today. Are we allowed to say we're going to continue this matter because the commissioners who are not here would not have had the benefit of the testimony we've already had today?
Yeah, that's just it. I mean, it would be a matter of here we have now through the wonders of technology, a video which presumably somebody could watch. Of course, in the past, you could have gotten a transcript and done that. That is something that the commission has generally not done in the past. We have proceeded, if there's a quorum present, we have proceeded with that quorum, made a determination in a case. If there has been a circumstance where not an insufficient number of votes, could be generated, then we have kept something open, advised other folks to look at a transcript in the past, because that's all we had available. But that has very rarely happened. I'd personally, I'd be inclined to dissuade the commission from acting that way, only because there is a quorum present. We are here, presumably doing what we're supposed to be doing, and I think that in all fairness to Mr. Vitale, who has been here today and sat through a long meeting, I think it's on us as an administrative agency to make a determination and be prepared to move forward.
I would go ahead.
I'm sorry.
No, I was just going to say, I kind of agree with that.
Mm-hmm.
I think we have a quorum. I think we've heard all the testimony. I think we ought to be the ones to act. What I'm mulling around in my mind, though, is whether or not we close the evidentiary part of this hearing and kind of take it under consideration and then come back at the next meeting and go ahead and render a decision. I've very much appreciated Mr. Vitale's email and his presentation, but quite frankly, I'd like to have a little bit more time to go back over that, take a look at it, and see how it relates to the specific counts that we're looking at in this case. So I would agree on one hand. I think the 5 of us that are here ought to go ahead and make that decision. I'm just pondering in my own mind whether we ought to do that today or whether we ought to do that at the next session.
Well, and my next question would become, is we're here today, and I've not pulled up my calendar to see what's happening. but let's assume one of us, of the 5 who are here today, can't be here next time. Now we can't even have a quorum to make a decision. So we're here, and I guess my first discussion would be is we should discuss whether we even have a violation. And in my mind, that's not a difficult determination. And then it would be the next step is, what as a commission are we going to do? But my concern is that for whatever reason, if we get to the next hearing and then we passed our time frame and then we can't make a decision.
Yeah. Well, I think any examination, we're going to have to start with count 2 and look at the counts 2, 3, 4, 5, and 6 and see how the evidence relates to each of those counts. So if we're going to do that today, that's fine. Certainly. Go ahead.
Mike, I'm sorry.
No, go ahead.
I'm open to anybody else. I mean, I've expressed one opinion. What I'd like to do is hear from everybody else and what they have to say about it.
Well, as one commissioner, I believe we should go forward with the 5 of us. It makes no sense to me to continue it. Scott, you made a good point. What if one of the 5 is absent next month or the month after that? Are we ever going to be able to get this done? I think we've heard all his testimony today. We read his report. I think we have all the information we need to make a determination on these various counts. And I would move to go forward.
All right. Tasha, your thoughts?
I would agree with that. I think that it's all pretty laid out in his response and in the comments that he's made here today, and I feel like we have enough before us that we can get it figured out.
Okay. Ms. Cunningham?
I'm good. Let's go.
You're good? You're good? Okay. Well, then with that, what we'll do is close the evidentiary portion of this matter, and we'll move into the deliberation decision phase. And I suppose what we need to do is take a look at the referrals as they were sent over by the Secretary of State's office. We have the 2nd, 3rd, and 4th referrals that have been tied together. Those involve the payment for the Facebook advertisements without reporting those expenditures. At least that's the referral. Discussion on counts 2, 3, and 4.
I would move that we find no violations, counts 2, 3, and 4.
I would second that.
Okay, we have a motion on the floor that would find no violations as to counts 2, 3, and 4. Further discussion by the commission with respect to that? All in favor of the motion signify by saying aye or raising your right hand.
Aye.
Aye.
Opposed, same sign. Motion carries by a vote of 5-0. No violations as to counts 2, 3, and 4. And then that would bring us to counts 5 and 6. Moving over to that right now.
And those are, I'll just interject and say, those are separate from each other. Count
Correct.
5 is, as stated in the complaint, failure to deposit all monetary contributions received by the committee in an account separate from a personal or business account of the candidate or campaign committee, 3517 D3A.
Okay,
What
so
is count 6, Bill?
Count 6 is a
Conversion.
3517-13-0 allegation that the beneficiary of a campaign committee converted for personal use. Similar to what we had in Elkins, that there was personal use issue as it relates to funds in the campaign committee. But that's under 13-0.
Okay, so with respect to count 5, which is violation of revised code section 3517.10 D3A, failure to keep separate the contributions received by the committee. Discussion?
Commissioner Norman, I move we find a violation.
Commissioner Brommer, I second it.
We have a motion to find a violation that's been duly seconded. Discussion? All in favor of the motion signify by saying aye or raising your right hand.
Aye.
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 Opposed, same sign. Motion carries by a vote of 5-0. Sixth referral has to deal with conversion for personal use items of value from the beneficiary's campaign fund in violation of revised code section 3517.13 as in Oscar. Discussion or a motion.
Commissioner Norman, I move that we find a violation.
We have a motion that's been made. Do we have a second to that motion to find a violation?
Commissioner Brammer, I second it.
Okay, we have a motion that's been duly seconded that would find violation with respect to revised code section 3517.130. Discussion. All in favor of the motion signify by saying aye or raising your right hand.
Aye.
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 Opposed, same sign. Motion carries by a vote of 5-0. All right, Mr. Richter, is there anything else with respect to this matter?
Now that we have found a violation, we need to impose some sort of a sanction. What is available to the commission? Obviously, under 3517-155A is to find that there's or to impose a fine amount, which could, there are various fine amounts available. We could go into, particularly if that's what the commission wants to do. We could send the matter for further prosecution, or we could find that there's good cause present not to do either of those things. So those are the options available to the commission.
All right.
This is Commissioner Norman, and I know we had this discussion recently as it related to Mr. Elkins as far as the most egregious of violations. And when I look at what happened here, I don't see this as the most egregious of violations. I understand that the money was coming in and it was immediately going out, and the intent was not to take money from the account. It was for the CCW. But I look at it and I go, a seasoned politician should know better than to put money into his account and bring it back out. So I'm of the opinion that I wouldn't want to refer this for further prosecution. I think we as a commission can hear that, and I would like to hear the opinion of the other commissioners.
Other
I would
commissioners?
agree. I would agree that it doesn't rise to the level of Elkins. But nonetheless, it wasn't our burden to prove that nothing happened here. And I'm a little concerned on these two counts that he maintains that he was told that what he was doing is okay. I don't think that's good enough. I think it was his burden to prove that he had actual information that misled him, if you will. And in the absence of that, I think a fine is appropriate. My belief.
Okay. Other commission members with respect to the issue of fine or sanction? Okay.
I guess my question is, he submitted these reports for over a series of years. It was and he says he would, put in there if it was put in and taken out and what it was for. Detailed records were kept. And I believe that from what he's shown us on here, I guess my question is how it was allowed to pass through without issue before. And I guess I can understand to a degree why you would feel like there's no problem if it's always been allowed to be passed through. So while I do agree that you should know your campaign finance laws, I'm wondering how it passed through with no question before this point, before this year, or before this past year.
Mm-hmm.
And
So I can
may,
see.
Natasha,
Go ahead.
Go ahead. Sorry.
I may be wrong, but I get the impression that he just kept detailed records, but the Board of Elections didn't know this was taking place.
Okay.
And
That's
so
fair. Thank you.
When he's doing his reporting, he's showing this is what the expenditures were, but the money that was coming in from CCW, he was sweeping out, so that wasn't being reported.
Okay.
From my
Thank you.
perspective on that, they didn't appear and testify or provide any information in that regard. That's a presumption because they filed a complaint. So I think the burden's on the complainant to prove that. and there's no contrary evidence on the other side to disprove what he's saying, I agree that it shouldn't have been done, shouldn't have been allowed. I just view the burden of proof a little differently.
Just to interject briefly, Scott, you mentioned Board of Elections. All these filings were made with the Secretary of State's office.
That's right.
Yeah.
Just
My
clarification.
Yep.
I would agree with Catherine. I have no issue with the fact that there were violations here. I think there's mitigating circumstances. We can conjecture what may have happened, but basically we have to make a determination based upon the evidence that's before this commission, the Secretary of State or whoever is the referring agency. I'm not picking on them. They have a right to be present, have an opportunity to be heard. The uncontroverted evidence in this case is that Mr. Vitale has reached out on a number of different occasions and had conversations with the Secretary of State, and they had advised him that it was acceptable practice. So I think that needs to be weighed in the balance. We can't conjecture as to what the Secretary of State may have said.
We also can't argue the negative, which is he's not submitting the actual accounts to them. It's whatever reports they get is what he's reporting to them. And he's indicated to us as a commission that he was just sweeping money out of the accounts and not reporting to the Secretary of State, which is contrary to everything that we know about campaign finance law.
Well, I believe there was testimony to the fact that Mr. Vitale had raised the issue on occasions with the Secretary of State, and they found it acceptable so long as detailed records were kept.
He also indicated that he searched his record for any type of written detail or memo and was not able to come up with such. Otherwise, he would have presented it to us.
Yeah, and of course, I asked that question, and as a lawyer, you and I, as lawyers, would go ahead and probably make memos to the file and have it typed up and put in files for the future, but a lot of people don't do that. We have nothing to dispute the fact that he reached out and he had the conversation as he testified to under oath.
And I don't disagree with you, other than the fact that I heard from Mr. Vitale on a number of occasions talk about how detailed he was as far as maintaining his records, detailed as far as his reporting, detail this, detail that, and he can't find a single memo from anybody telling us what he did was appropriate. And it's certainly contrary to what campaign finance law, which is you don't put money into an account and then sweep it out.
Well, I think there's two issues here. I mean, the issue is whether or not there's been a violation. And secondly, then what's the sanction going to be? I think we all agree that there's been a violation. So the question here is the sanction. And I'm just saying that I think there's a lot of mitigation in this case based upon the state of the record and the evidence that's been admitted.
I think we've already agreed there's violations because we've already had that vote. So now it's just a matter of what are we going to say to the not only the general public, but candidates who are doing this and having accounts and saying, I'm going to put money into my account and I'm going to pull it out and then there's no accounting for it. I mean, it's the same issue we had with Elkins. This isn't, and I'm not saying this is anywhere near Elkins. This isn't nearly egregious, but you can't repeatedly put money into your campaign account and pull it out, and then there's no accounting or no recording of it. It runs contrary to everything we know.
But in the Elkins case, we had the Board of Elections represented, and they were heard. Do you have a dollar amount that you have in mind for a fine on this, Mr. Norman?
I'm not sure I do at the moment. I mean, I'd like to just maybe reflect and think about it for a moment.
Mm-hmm. Does anybody else have thoughts on what the sanction should be for the violation?
Well, I think that the only mitigating circumstance here is that the Secretary of State's office did not have anyone show up. But as far as the violation itself, we already ruled on that. And to look past that without finding some kind of culpability. Look, I said it before, and I truly believe that if we would have saw some physical evidence that he was misadvised for the last 7 years, that would have been significant mitigating evidence. But we don't have that. And so if we're looking for an amount, I think we should, given that we did not have the other side presenting any rebuttal here. I think that $1,000 on each charge would be sufficient deterrent.
Okay,
Dennis, I want to make sure you're clear. You're talking a total of a $2,000 violation, one on each that we found a
Yes.
violation?
Yes.
Okay.
other board members? Catherine, you're awful quiet.
I disagree. I think it's too, I think I'm just troubled by I understand the Secretary of State's, I mean, I looked at their complaint, I looked at the evidence that they have, and I understand that we want to send a message and we say that you can't do it. But I think it's based on the facts and circumstances in each case, and I just don't see the facts and circumstances supporting that kind of fine, my opinion.
What kind of fine would you find acceptable? What range?
I don't know. I mean, it would be a lower range and or close to a no fine for me.
Okay.
And I'm not in that same boat, only because it seems to me that if you're continually doing this over and over again, I think something needs to be said to the general political population that you can't do this, put money in your account and take it out. As it related to Elkins, we think about what we did to his mother, who was the treasurer of the account, and we know that that was just a pass-through, and we gave a $500 fine to her. It seems to me that I'm thinking about a $1,000 fine for both counts.
All right, we do have a motion.
I don't think we have a motion yet. Could we hear from Natasha, and maybe Mike hear your thoughts as well?
Yeah, I don't believe there's a motion out there at this point, no.
No, that's what I was asking. Do we have a
Oh.
motion? Okay. Natasha,
I guess
go
from
ahead.
my aspect, I'm sorry.
Go ahead.
From my aspect, I guess, mine would have been a $500 fine for both counts combined, is what was in my head when we started talking about it, based on some different things that, that I've seen just in my short time on the commission. But I guess like the figure that popped into my mind was $500 for both combined. So.
Yeah, I could live with that. I could live with $500 total fine, $250 and $250, or however you want to break it up. And I just think that's appropriate under the circumstances. And again, just looking at the state of the record and the evidence that we have in this case. So.
Well, for me, it would be a travesty to say that we don't come to an agreement, because if we can't come to an agreement, then we don't have a quorum, and this case walks away. I find it to be a bit more egregious than maybe you do. Obviously, Dennis feels a little bit differently. Maybe we can come to an agreement, let's say $750 on a combination of both. Is that something the commission can live with?
I'm agreeable to that.
I could live with it.
Ms. Cunningham?
That's a no for me.
I lost Mr. Kreitz. I don't see
No,
him anymore.
no, I'm sorry, I said no. I think 500 is reasonable.
This is Commissioner Norman. I move that we make a fine of $500.
We have a motion, and is that for both counts total, 250 and 250? Or are you going to do it for?
Correct. It's a total of 500. It's not separated between the two.
That's fine. Okay, so we have a motion to levy a fine of $500 for both count 5 and 6 violations. Do we have a second?
Second, Kaufman.
All right, we have a motion that's been duly seconded that would impose a fine of $500 for both counts total for counts 5 and 6. Further discussion? All in favor of the
Do a
motion?
roll call, Mike. I think we
Yes.
should do a roll call on this
I
one.
think we should do a roll call.
I think that's fine. We'll do a roll call.
Ms. Kaufman,
Yes.
Mr. Bromer,
Yes.
Ms. Cunningham,
Yes.
Mr. Norman,
Yes.
Mr. Kreitz, Chair
Yes.
Kreitz.
Yes.
That motion passes unanimously.
Okay. Any other business with respect to this matter?
This
Mr.
matter is
Executive Director?
resolved.
All right, Mr. Vitale, thank you very much for your time. Appreciate your presentation. Wish you the best of luck. Take care, sir.
Thank you and thank the commission.
Okay.
Thank you.
All right. One final item on the agenda. Our next meeting is May 6, 2021. Any other business to come before the Ohio Elections Commission?
Not that I am aware. I don't have anything else.
All right, if not, I'll entertain the motion, we adjourn.
Before you adjourn,
Yes,
what about our signed minutes? What's the status on those?
We're doing them virtually.
Yeah,
Yeah.
we're doing, you
Electronic-
guys agreed a couple meetings ago that we would just, do an electronic signature, and Chris has been doing that after we approve them.
Okay, I can't
Your
remember
voice is good
getting
enough
any
for us.
recently.
It was
Your
at
voice
one
is
of
good
the
enough for
March
us.
meetings, as I recall.
No, I remember doing that. I just can't remember getting any signed minutes.
That's why you haven't
That's why
gotten
you
it.
didn't.
If you go online, though, you will see that they're there and they are signed in
You
your
have
own
signed them.
distinctive ways.
You have signed them.
Okay.
By the way, it's snowing here in Columbus again.
Oh, didn't it? Oh,
Lord.
great. I get to drive down to Cincinnati. Yeehaw.
I've got to head out for another meeting, guys. So is there any other business to come before the commission?
Move to adjourn.
All right, do we have a second?
Second.
All right, all in favor of the motion to adjourn signify by saying aye, raising your right hand.
Aye.
Aye, opposed, same sign. Motion carries. Thanks an awful lot. Good meeting.
Thanks,
Got a lot-
everybody. Good job.
Got a lot
Appreciate it.
accomplished today. Bye-bye.
Bye.
Thanks, Allison, since I see you're still out there. Appreciate your efforts.
Hi, yeah, of course. Thank you so much. You have a good day.
Will do. Same to you.
Thank you.
All right, I just Jane, stop recording.
I haven't yet, no. Now that you're gone and you're done, I have. Hello, Mr. Norman. How are you? You're becoming very hostile toward politicians, aren't you? Well, you would think he should have, yeah. But at the same point, I mean, if he is, yeah, but I am going to give him the benefit of the doubt as it relates to that. And so